Fiona is a barrister, as I said at the beginning, in 33 Chancery Lane. She acts domestically and internationally in civil, commercial and criminal cases, obviously in the fraud, money laundering, bribery and corruption area. She represents prosecuting agencies, individuals and corporates, and as I understand it, is currently preparing for a trial in January where she is representing a company charged with corrupt practices. Fiona, how things have changed since I left to come to Turkey Caicos Island. Your practice has blossomed, and it's rightly so. Can I hand over to Fiona? Thank you all very much indeed. It's been a very interesting session so far.
Well, thank you, Andrew, and thank you very much again, Charles, for that fascinating address. Obviously, we'd all hoped by now that we would have the final definitive answer on the post-Brexit landscape, but it's still not yet to be. Perhaps during the course of the day, as I see from the news flash, more progress will be made. But we're going to move on to today's panel debate on internal investigations, single nation and multi-jurisdictional, and a European perspective in particular, because most of our delegates to this webinar undertake internal investigations from the UK, but with international angles to them. And so we'll be focusing our discussions this afternoon on internal investigations from a non-UK perspective. And in that vein, we'll be taking in the view from 3 different jurisdictions: Paris, Stockholm and Zurich, on the issues that arise, including GDPR and privacy, the impact of labour law, blocking statutes, and complying with investigations by other regulators such as the Department of Justice in the USA. So we're delighted that 3 eminent panelists have kindly agreed to join us, and they'll each start by outlining their own experiences and tips from internal investigations in their jurisdictions and how their cases have engaged issues in other jurisdictions. We'll then turn to a debate, and we'll include any questions that delegates may have and submit through the chat function. We didn't get any questions for Charles, but if you would like to submit some, please do so using the chat function, and I'll pick up on them where I can. But first, I'm very pleased to introduce Erika Viking Häger, who is a partner and advocate at Mannheimer Swartling in Stockholm. Erika is the head of its corporate sustainability and risk management practice group. She advises clients on environmental, social and governance matters. And as well, of course, as being on the board of her firm, Erika is also a board member of the famous Swedish retail fashion company H&M. So Erika, over to you.
Thank you, Fiona. Thank you for inviting me. So I will be happy to share some experiences from the Swedish perspective. As you know, Sweden is a relatively small country up north with a population of about 10 million people. The vast majority of our companies, actually 0.1% of all our companies, have less than 250 employees. Having said that, we do have a quite impressive number of large companies with a truly global business and strong international brands. So you may have heard of companies such as Volvo, trucks and cars, Ericsson, communications technology company, Skanska in construction, IKEA, furnitures in flat packages that you may be familiar with. We also have a number of banks, Nordea, SEB, Swedbank and Handelsbanken. And considering our small population, the domestic market has not been big enough for growth. So expansion has been part of many Swedish companies' business strategy for a very long time. And if we turn a little bit to corruption, because I think for us, corruption has been the main trigger for internal investigations. So if we look at corruption in Sweden, Sweden has a very low level of corruption. If you look at Transparency International's corruption perception index, Swedish has a score of 85. We have Denmark that tops the list as the least corrupt country in the world, and Sweden is number 4 behind Finland and New Zealand. Having said this, it may be a bit surprising to learn that 2 Swedish companies are actually on the list of the top 5 biggest settlements with the US Department of Justice under the FCPA. If we look at the list, at place 4, we found Ericsson, the telecommunications communications company. In 2019, the company settled on a little more than $1 billion for corruption in Djibouti, China, and a couple of other countries. On place 5, we find Telia, the former state-owned telecoms operator of Sweden. Telia also settled with the Department of Justice, and in 2017 it was a settlement in an amount of also $1 billion for corruption in Uzbekistan. And Telia also settled with the Dutch authorities for claims of corruption. In addition, we have in recent years seen some of the Swedish banks involved in quite extensive money laundering investigation. Earlier this year, we had Swedbank that was fined by the Swedish Financial Supervisory Authority in an amount of approximately 400,000 euros for deficient handling of money laundering requirements in its Baltic operations. And there are also speculation that US authorities may have an interest in this matter. And we also saw the Swedish bank or Finnish bank nowadays, Nordea, being involved in the Panama Papers. So one could wonder, how can a country with such a low level of corruption and such a small country end up with companies that are breaking world records in paying fines to foreign authorities for corruption? Obviously, I don't have all the answers, but I think there are a combination of reasons for this. I think firstly, we have the very strong expansion into countries and regions with a significantly higher risk for corruption than the Swedish home market. We also see inadequate procedures for detecting risk for corruption in companies, as well as procedures for preventing incidents. And also management who hasn't really been trained for navigating in those complex markets. I also think there's a part to this is that Swedes are pretty much brought up in an environment where you don't bribe, and you should trust the government and you should trust your counterparties. There also, to a certain extent, an explanation in the Swedish management style where you should trust your employees and assume that they will do the right thing and always act in the best interest of the company. And there are simply not so many controls in place if you look at the traditional way of managing Swedish companies. So I think all of the above combined with a corporate governance style where local subsidiaries have been given a lot of freedom to develop their business abroad, as long as they can show good results and send profits back to the headquarters in Sweden. So after this kind of long introduction, what does this mean for the practice of investigations in Sweden? I think to begin with, obviously, this means that me and many of my colleagues in my own firm, but also in other Swedish firms, have been extremely busy when it comes to internal investigation over the past years. We've had the opportunity of leading investigations on a truly global arena, and we've had opportunity to work with extremely professional colleagues at law firms around the world. And that has brought us interesting experience when it comes to differences between our own legal system and foreign jurisdictions. And I thought it could be interesting maybe to share a few examples of what we have seen. For example, in Sweden, corporations are not subject to criminal liability. Criminal liability could only happen for individuals. And we understand that that is not always the case in other countries. Then obviously, if we go to our legal system, we are a civil law country, and investigations with a reach into common law jurisdictions poses certain differences. Particularly, I think, when we had investigations led by US authorities. We also have the issue about settlements. In Sweden, it is not possible to settle with regulators or prosecutors. It will have to be a court ruling or a decision by the regulator. It's not possible for the company to negotiate. And that is also something that we have learned that is part of the game in many other countries. I think it's also one other theme goes to timing, and in Sweden, a preliminary investigation in a criminal case can go on for years. And we have seen that in other countries where the possibilities of settlements, for example, could speed up that process significantly. And another very big difference is that we have very limited sanctions against corporations. I already mentioned that we don't have criminal liability. There is a small possibility for sanctions, but our corporate fine has been kept at approximately 100,000 euros for many years. Actually, at the beginning of this year, it was raised up to 50 million euros. Partly because of a lot of criticism from foreign authorities and the OECD. And we also see more severe sanctions being developed by the Financial Supervisory Authority and also from authorities under the GDPR. And this is, of course, something which is very different for our Swedish companies when they face investigations abroad, where sanctions can be on a completely different level. And I just mentioned the two settlements of Ericsson and Telia under the FCPA. And one more thing to mention is probably that we have no established form of cooperation in relation to regulators. And that is also, of course, also something that we see as a big difference. If you are subject to an investigation, for example, with the DOJ, it's part of the game. You are required and expected to cooperate. And that's not the case really before Swedish authorities or even courts. And maybe the last thing I would like to mention goes to self-reporting, which we also frequently see is an issue that has to be addressed. In Sweden, there is not really a general duty to self-report crimes to the authorities. There are, of course, exceptions to that, but typically there's no general such rule, and that is also different. And I think I'll pretty much stop there, Fiona, and hand over to the next person. Thank you.
Well, thank you, Erica. I mean, that was really interesting, and I was particularly intrigued to hear that you don't subject corporates to criminal liability in Sweden. But we may pick up on that again later in our debate. But let's move on now to our next speaker for an initial presentation. We're delighted to have Haeri, who is the chair of the Commercial Litigation and White Collar Practices at Quinn, Emanuel in Paris. Welcome, Cami. Cami regularly advises French and foreign clients on matters involving commercial and corporate disputes and white-collar crime. And he's got significant expertise in international compliance. He routinely assists companies with investigations conducted by French and foreign regulators. Cami, the floor is yours.
Do you hear me? Well, thank you very much. Thank you very much, Fiona, and thank you very much for inviting me to participate to this panel. I'm happy and honored to be with all of you and with such a talented group of panelists. Well, internal investigation has gained a critical importance in France throughout the last couple of years. And actually, it's interesting to see how our existing practice has matched with the evolution of a new set of rules and statutes that have been implemented in France. The most critical change comes from a statute that has been implemented in 2017. You have certainly heard of this statute, the Sapin 2 statute, that has created in France a new series of duties for corporation and large corporation. First one is that now there is a structured duty for large corporations to implement. Erika was making reference to that kind of duties also in Sweden, a series of comprehensive tools dedicated to, first of all, raise the awareness of the company on misconduct and on corruption and other type of violations of the law, and also to detect those type of misconduct. So that's one set of rules. The statute also provided a new agency. We have now a new regulator, the French Anti-Corruption Agency, which is an independent regulator, not the prosecutor, a different regulator, whose job, of course, is to provide some guidance regarding the enforcement and transformation of those duties, but also to prosecute and to investigate on the way a company has properly or not implemented those rules. And basically, the AFA, the French Agence Française Anticorruption, has a very wide range of powers, enabling them to request information from a company, interview the members of this company, even somehow raid this company, with a view to understanding whether the measures that you have implemented internally are adapted, are consistent with the exposure of the company, with the background of the company, with the mapping of the risk that is inherent to this type of activity and that type of market in which this company is trying to operate. And actually, the system is quite interesting. I think it's probably a world premiere. If after this kind of long and thorough investigation, they make some recommendation because they consider that your system is not adequately organized, that you have not allocated enough resources to structure those tools inside the company. Of course, after an escalation procedure, you can be prosecuted and end up before the sanction committee of the AFA and be fined 1 million against a company, up to 200,000 against an individual. And interestingly, I think it's the only, to the best of my knowledge, system in which you can be prosecuted and fined because your detection system is not concrete, thorough, comprehensive enough, while no violation of the law on the merits have been identified. So regardless the fact that there is no violation of any duty regarding corruption, influence trafficking, tax fraud, or money laundering that is identified, if they consider that your system is not solid enough, you can be prosecuted. And of course, among the standards, among the methodology of analysis, your ability to deploy a proper and concrete internal investigation will be analyzed with scrutiny. And the last thing that Sapin 2 has provided, which is absolutely critical, is that we have implemented in our system for the first time a DPA à la française. We have now the ability to settle, not with everyone. With corporations, the individuals cannot be eligible to that, which is rather interesting in terms of incentive, because basically the law says implicitly, if the executive, if the management of the company is involved, then the company itself can get out of the hook through, of course, a comprehensive, structured deal involving maybe a monitorship up to 3 to 5 years, maybe generally 3, if you manage to end up with the DPA. But there's nothing that can be done against the management. And on top of that, I draw your attention to the fact that the French DPA, the CGIP, implies that the company recognized the qualification of the facts. So when a company has entered into a set of settlement with the prosecutor, it might be even more difficult for the individuals who will be kept prosecuted as an individual to try to reverse the flow and the trend of the investigation. So of course, as you may imagine, this DPA implies a certain level of cooperation, or I would say a certain level of sincerity. And one of the standards to measure for the prosecutor's office the sincerity of a company is to see whether the internal investigation have been thorough and whether they have conveyed a certain level of cooperation. And actually the CGIP has been extremely useful. We have, I think, in 3 or 4 years, the amount of fines or contribution, because it doesn't imply a recognition of guilt for a company, and it's not on the criminal record of the company. So it's a settlement, has reached something like 3 billion euros, and there's no such achievement that can be done by any court in such a limited amount of time. So the system proves successful. But of course, as you may imagine, it has completely changed the paradigm in France of what an investigation is, because now every investigation, every identification of a risk in a company implies that we create some kind of angle and we try to reach a certain environment in which the conditions to discuss a settlement will be optimized. And so first of all, that harmonized the situation of France vis-à-vis some other countries, because quite strangely, we have a lot of regulation in France. We always loved regulation, and we've had crimes, offenses, grounds that have been here forever, but we were not just enforcing them. And so we reached about 10 years ago a certain level where you had some kind of discrepancy between the fact that we had the offenses and the grounds available in our system, but we were not enforcing them. And the discrepancy was that we were probably more scared by foreign regulators than we were by our own regulators. We have been highly criticized by the OECD, hence the implementation of this very thorough, ambitious set of rules that, as I mentioned to you, changed a little bit the way we apprehend compliance and internal investigation. And of course, we have imported, because you may imagine that all those are extremely influenced by the Anglo-Saxon, the UK, and the US system, and the US standards. And for practicing in a US firm, actually, we have been implementing the standards that were deployed in USA or UK for many, many years. And it's interesting to see how slowly but surely the way the Sapin 2 statute is now deployed, although there are no specific rules governing the actual functioning of the investigation in the law. So it's a little bit of soft law and best practices that we import from other countries. We see that now we are reaching a certain level of harmonization and hopefully a certain level of credibility. Result of which is the fact that, for instance, you have heard of that, in a major investigation against a French bank, Société Générale, we have witnessed a couple of years ago a first dual press release between the PNF, the French Financial Prosecutor's Office, and the DOJ, with a split of the fine of 500 million between the two countries and entities. The same thing recently, of course, the major Airbus settlement, including the SFO, the DOJ, and the French PNF, 2 billion for the French Treasury. And that is a very interesting precedent of a complete joint investigation in which, by the way, some standards and some best practices, and we might discuss of that at a later stage, have been implemented. And that shows that now we have reached in France a certain and a critical level of cooperation. And we have been also able maybe to handle, I'm talking about the regulators, because it was more the absence of dialogue between international regulators that was sometimes making more difficult the deployment of large investigation in France. Maybe some issues regarding professional secrecy, legal privilege, transfer of information, blocking statute have been properly treated. And so the standards deployed at the occasion of those multi-jurisdictional investigation will probably contribute to our doctrine now, it being specified that, as I mentioned to you, the Sapin 2 statute doesn't provide very specific guidance regarding the way an internal investigation should be conducted. So every community in France has provided its own soft law. The lawyers have provided their soft law, the PNF and the AFA have provided, and each of the bodies try to, with his own agenda, to contribute to the general thinking about all this, but there is not yet a harmonized approach. And the last thing that I would like to point out, and I know that this webinar is more about internal investigation than a lecture about the sociology of the French judicial environment, but there is one thing that is absolutely critical, and we all have to bear in mind when dealing with an investigation in France. As I mentioned to you, the CEGIP, the Sapin 2 statute, is transforming the spirit in which you apprehend an investigation, not only an internal investigation, an investigation at the broader term. Why? Because historically, there was not a lot of dialogue between regulators, prosecutors, and judges on one hand in France, and the lawyers on the other hand. We come from two different bodies. Of course, after a few years in law school, we choose different paths. Judges, prosecutors together pass a specific exam. They attend a specific school. They belong to a unique body, and they have changes in their career throughout the years. But the exchanges between the two communities of judges and prosecutors on one hand and lawyers are not that often. We don't have this culture of mobility between them. And so our relationships have been for many, many years, although very cordial, rather confrontational. And now you have a change in the spirit, because now you have to create the conditions of a dialogue and negotiate, which implies that we change the way we apprehend the appearance of a risk, self-disclosure, implementation of internal investigation. So all that somehow participate to this new approach that we must have about internal investigations, not to mention, of course, some other elements such as blocking statute, RGPD, professional secrecy that we will certainly tackle through the course of this webinar. I hope that I was articulate and sufficiently short, Fiona.
Yes, thank you ever so much, Camille. That was very helpful indeed as an overview to where you are right now in France on these internal investigations. Turning now to Zurich and Lalive, we're very pleased that Simone Nadelhofer joins us. Simone is also a partner and specialises in white-collar crime and regulatory investigations. She advises clients on crisis management, compliance, and remedial action, and she's regularly retained by corporate clients in cross-border investigations, both in Switzerland and involving foreign authorities. Those include the US authorities, and she leads, as part of her practice, large-scale internal investigations. So Simone, may I come to you next, please?
Yeah, it's a pleasure. Thank you very much, Fiona, for inviting me to this panel. It's an honor to participate in these interesting discussions and also to learn something from other jurisdictions. So Switzerland, like Sweden, is a very small country. I think we are even smaller than Sweden, but yet we have a long-standing tradition of investigations because as you know, Switzerland is a financial center, and almost every time that there is a scandal somewhere abroad, Switzerland has a role to play in it, because very often, in particular, when we speak about corruption, monies would flow through Swiss bank accounts, sometimes held by offshore countries. I think there has been a huge change in Switzerland since the financial crisis in 2008. I think before 2008, we had a strong banking secrecy, and there was no questions for Switzerland to exchange information on Swiss bank accounts, except for mutual legal assistance proceedings in criminal matters when a foreign authority was able to show that there was a suspicion for a criminal offense. But other than that, Switzerland did not exchange any data, and that has changed since 2008, and since there was an increasing international pressure on Switzerland. And now banking secrecy has been heavily relaxed, and Switzerland would also exchange information with foreign tax authorities based on OECD-based tax treaties. And this would obviously, again, nourish further investigations. I think, unlike Sweden, Switzerland has introduced corporate criminal liability. We have it since 2003, but actually it was only applied for the first time in 2011 in a case against Alstom in Switzerland. It was also related to a bribery case in various jurisdictions abroad. And I think since 2011, we have seen a number of criminal investigations against companies in Switzerland, so domestic criminal proceedings based on corporate criminal liability, be it for corruption, money laundering, etc. So several banks are currently also prosecuted for money laundering, for instance, in relation to international scandals like 1MDB, or you all know the Lavajato Odebrecht scandal. So I think in a first period, investigations in Switzerland mainly concerned the financial sector. And I think one very big wave of investigations related to the Swiss, the US program for Swiss banks. This was a program which after UBS had pled guilty in the US for aiding and abetting tax fraud by US taxpayers. This program had allowed all Swiss banks who wanted to come up to cooperate voluntarily with the US authorities and to avoid being prosecuted in the US. And this has prompted numbers of internal investigations within banks, because these banks had to gather all information they had relating to US accounts. They had to establish the structures, etc., and had to share that information with the US authorities. Also something that was particular to this US tax program is that a bank who participated in the program had to appoint a so-called independent examiner who had to verify the results of the bank's fact gathering and to confirm towards the DOJ that the results presented by the banks were indeed correct. So another investigation by the independent examiner. I think another interesting experience in which I was involved and which I would like to share is the US monitorship to Credit Suisse. I mean, this was also relating to the tax dispute between Switzerland and US. And Credit Suisse had settled in the US, both with the DOJ, but also with the DFS. And part of this settlement was that DFS had appointed a monitor who then came to Switzerland with a very large team, and he was here for more or less 4 years to complete the monitorships. And he not only gave recommendations for the future, but he also made an investigation into the past to see what failures within the bank had led to these offenses, and to avoid this to happen in the future. So our firm was then retained as Swiss counsel to the monitor, and that was very interesting because it was for the first time ever that a foreign monitor was operating on Swiss soil. And I think one important factor is that the monitor had to do everything on Swiss soil, so they couldn't do it from the US remotely because of Swiss blocking statutes, banking secrecy, data protection, etc. So there were very strict rules as to how the data gathered by the monitor could then be exported and used by the US regulators. And I think one thing also in the Swiss system, also like Sweden and unlike France, we don't have DPAs. Which makes prosecutors' lives rather difficult because I think DPAs are a very good thing for prosecutors. And there were initiatives. The Swiss Office of the Attorney General was keen on introducing this instrument, but it was then eventually rejected by government and And so we don't have it, but in practice, it still happens, and quite frequently actually, that in criminal proceedings against companies, there is a de facto settlement because the prosecutors have the possibility of issuing what we call penal orders, which do not have to go to court when the person against, or the company that is being investigated, would admit the offenses which are held against it. As to fines, they are rather moderate when you compare it with what we see in the US and maybe also the UK. We have a maximum of 5 million Swiss francs of fines against companies, but where it can hurt is with the disgorgement of illegal profits. And there we have seen cases where it was several dozens of millions that have been disgorged in illegal profits. And so this is still something that can hurt a company. And another interesting development I would like to share is that, as I mentioned, I think in the first period, investigations were mainly relating to the financial sector. There have been a few corruption cases in the industry, but now, and maybe also due to the pandemic, we see an increasing focus on the healthcare and pharma sector. And I think this is a development that has started, or that we have seen in the US. There have been several cases also against Swiss pharma companies, notably Novartis, as you certainly all know. And over the last 15 months, I've been retained in 2 cases to conduct investigations in companies in the healthcare sector. And what I've seen has come as a surprise, because even though the sector is heavily regulated, there are still weaknesses in compliance systems. And what I see is corruption all over the way, even in Switzerland. And I think what I saw is only the tip of the iceberg. And with the pandemic, the interest in the healthcare sector will even increase, because everybody feels personally how important this is. And this may also prompt regulators to take a closer look into what is happening there. So I'm sure we have interesting times ahead of us. Thank you very much.
Thank you, Simone. Well, that was again a fascinating insight into current themes in Switzerland. You touched on blocking statutes as part of your presentation, and as we've heard, increasingly internal investigations obviously have a cross-border reach and extraterritorial effect across Europe and indeed around the world, with potential criminal ramifications in other jurisdictions. Coming to you first, Cami, can you tell us a bit more about issues you might have in accessing data in another jurisdiction to enable you to conduct your investigations effectively, particularly possibly the type of blocking statute that Simone's just touched on?
Well, thank you very much, Fiona. There are 2 aspects in this question. The first one, of course, is getting information from abroad. And we're not always facing countries that are cooperating. So I would say the first issue is cooperation. Trying to collect information in the current context of an internal investigation in some countries that are not willing to cooperate, whose system of cooperation, judicial cooperation is not sufficiently mature, and there is no, I would say, political decision or willingness to participate, is absolutely problematic. The second issue, of course, is also political, but it's more about the management of reciprocity. When you have different regulators involved, it is sometimes more complicated in the arrangement that you have with them about the fact that collecting information that would normally be subject to their investigation would be useful for your very own investigation, especially as you expect to be able to enforce your very own blocking statute, which leads us to what you just mentioned about the French blocking statute, which is a kind of odd text that is available for us. It's been there for forever, basically. It was first implemented in 1968, and it was rejuvenated and completed in 1980. And don't want to force you to reading, but there are just 4 lines, and I want to read them to you because you will see how interesting and global it is. Subject to treaties or international agreements and to currently applicable laws and regulation, it is prohibited for any person to request, seek, disclose in writing, orally, or in any other form, documents, information of an economic, commercial, industrial, financial, or technical nature directed toward establishing evidence in view of foreign judicial or administrative proceedings or in relation hereto. So basically, the French blocking statute, it's Article 1 bis of 1980, technically prohibits anyone in France to participate anyhow to any type of foreign legal proceeding by providing information. Either it's I would say, vertical investigation led by a foreign regulator, but even technically in a more private dispute before a foreign court, through which you are requested to participate to an interview as a witness, to be examined or cross-examined for a deposition. And so we had to manage a way of discussing the proper enforcement of this, both from a legal but also political standpoint, because to a certain extent there have been decisions in the US disregarding the French blocking statute. But we have witnessed one thing when it comes to white collar and investigation, is that the tactical power, the political power of the French blocking statute is increasing. The French blocking statute has been enforced once in a decision in 2007, confirmed by the French Supreme Court, once. So you show that sometimes we're also embarrassed because the companies that we represent are global, and the executives, the managers, they want to travel. So if you are retained in JFK or at Dulles Airport because of a contempt of court, because you have refused to provide information in the context of an investigation led by the DOJ, this is problematic. So this is an instrument that must be dealt with care. And of course, as you may imagine, because of the reciprocity, it creates sometimes a difficulty, or it is used as a tool to say to the foreign regulator, we have the blocking statute, why don't we create a system that would enable our very own regulator to deal with the French information while you cooperate with them regarding the part that is located abroad? So this is generally the solutions that now more and more, especially in the context of the recent DPAs that I mentioned in my earlier presentation, have been reached this recent time. And the last thing maybe, but I think that we will get into this at a later stage, is the discrepancy between the concept of legal privilege in foreign jurisdiction and the concept of professional secrecy in France. But I think we will get into this.
Erica, what's the view that you have from Stockholm on this?
From Stockholm, I think when it comes to internal investigations and the possibility of accessing data in other jurisdictions, I think a lot of focus has been on data privacy laws. In the past, I think there has been an understanding that as long as you comply with EU laws, currently the GDPR, you should be fine, and you could go out and collect data according to those standards. But I think it's becoming increasingly clear that many countries, I think even dare to say most countries of the world, have certain kinds of protection for personal data, which affects the possibility of data collection in other countries. I think we have had the experience of reaching out to various, sometimes peculiar jurisdictions across the world. And at the end, we always engage local counsel, of course, to make sure that it is being done in compliance with the local laws. And I think there are 3 categories of laws, essentially. We have the first category of countries which have implemented laws which are quite similar to the EU laws, like the GDPR. I think, without being an expert, that maybe Australia, India, Japan, for example, have at least similar concepts when it comes to the protection of personal data. Then you have other countries where it may not be the personal data, but it could be other types of interests that are protecting data. And one obvious example would, of course, be China, where you frequently need to check whether an export of data could be considered violating China's protection of state secrets. And then I think we have also seen that we have a third category of countries without really data protection in terms of specific privacy laws, but there are still privacy rights or similar rights under the constitution. That has, for example, been our experience in the Middle East. Countries like Saudi Arabia and other Middle Eastern countries, we have been advised by local council that there are privacy rights under the constitution and even under Sharia laws in some circumstances. So I think this is something it's important to be very aware of. You shouldn't just look to the laws in the home country. Obviously, you always need to make sure that you're doing the right thing in the country of collection. And this can take time and can be quite complicated, especially if you are dealing with a request from, let's say, US authorities, and it's expected from you to be very swift in producing documents and other types of information.
Thanks, Erica. Simone, you touched in your presentation on the US DOJ monitor having to be present on Swiss soil in order to conduct their monitoring effectively recently. Can I come and develop that a bit more? What issues of tipping off data privacy and not compromising internal investigations do you face in Switzerland and other jurisdictions?
Okay, maybe first of all, what you said about the monitor, and maybe just to echo what Camille also said, Switzerland has a blocking statute that is very similar to the one France has, and so the rule is that a foreign authority may not conduct any acts of authority on Swiss soil, for instance, to feed proceedings abroad, but this holds also true for companies that are being investigated. They may not, for instance, investigate in Switzerland without proper review before feeding information into a foreign investigation, or if, for instance, foreign lawyers conduct an investigation in Switzerland, for instance, to cooperate with the DOJ. And I think that the rule is that a foreign authority who wants to have access to information from a Swiss company has to do it via a request for mutual legal assistance, be it in criminal matters or in tax administrative assistance, maybe also civil assistance. If that is not possible, the law foresees the possibility of requesting an authorization from the Swiss government for the foreign authority to engage in such acts. And that's what happened, for instance, with foreign monitors who act on Swiss soil, because they arguably act on behalf of a foreign authority, which is problematic if they conduct their investigation in Switzerland. But to my knowledge, all monitors who have acted in Switzerland have obtained a waiver or an authorization from the Swiss government, which allowed them to conduct their review for the purpose of reporting then to a foreign regulator. So there are ways around it, but other than that, this Article 271, our blocking statute, is really a source of frustration, in particular to foreign lawyers who need data that is based in Switzerland for the purpose of their investigation. And I think you also asked about tipping off. So obviously this is an issue that you have to keep in mind in every investigation. And usually I think when starting an internal investigation in a company, the company always has to consider who should be informed, who should be part of the investigation, in order not to tip off employees who have potentially been involved in behavior that is under investigation. So ways to do that is, for instance, to have a steering committee which would be comprised by a member of the board who has not been involved in behavior that is being investigated, and who can to whom the law firm that conducts the investigation can report to. And obviously also information in relation to an investigation or the report should only be shared with a restricted group of persons on a need-to-know basis.
Thanks, Simone. And Cami, what's your take on this?
You mean the collecting information and the tipping off? Well, in France, I would say that although there hasn't been any case law regarding this point, but I would rely on Article 12, 13, and 14, if I remember correctly, of the GDPR regarding the different exceptions for not informing someone of the existence of an investigation or an employee. There are different criteria, the proportionality of the necessity to inform. This is fine. But the necessity to preserve the information. And the third, of course, being the existence of a professional secrecy. So this is something that we can manage. In France, it doesn't seem to be, although our labor law, as you know, is extremely sophisticated, and sometimes we have difficulties much more on the coexistence of an investigation that could identify a behavior from an employee, which might end up into a labor law procedure, as opposed to actually the implementation or the nuances of the GDPR. We're very, very cautious about the data privacy in France. We have a very, very powerful, sophisticated, aggressive, in the good way, data privacy agency and authority. But as far as investigation are concerned, I think we are rather preserved regarding the duty to inform. Of course, there is a difference between former employees and current employees regarding the access to their data or their duty to participate, but I guess this is another issue.
Yeah, well, thank you very much for that. Erica, do you have thoughts to contribute on that particular topic? And then I'll take a question that's come in from the floor for you.
Well, with respect to tipping off, I mean, in Sweden, there's a tipping off ban when it comes to anti-money laundering issues, of course, I think in many countries. Apart from that, I think it's more a practical issue in terms of how you are structuring and dealing with your internal investigations and how not to compromise the investigation. And I completely agree with Cami that I think for us, balancing requirements under the GDPR and still being able to conduct an efficient internal investigation, that's probably one of the biggest issues right now.
Thank you. Well, Erica, I must pose a question that's come in specifically for you, and it touches on some of what Charles was speaking about in his opening remarks. The question is, how do you see the cooperation between Sweden and the UK in relation to investigations and enforcement actions, assuming a hard Brexit, with the UK likely losing access to various databases and certain EU schemes, such as the European Arrest Warrant and the European Investigation Order? Are there other agreements in place between Sweden and the UK that could help with cooperation going forwards?
That's an excellent question, and I wish I had a sophisticated answer to it. I think we are all doing our best to trying to figure out what's going to happen in terms of cooperation between Sweden and the UK. I think we have a tradition of very strong ties between the two countries, and it's my understanding that we have had a very good cooperation in the past. But to be honest, I don't have the answer to the question. We don't know yet what's going to happen. in terms of that type of cooperation. I think it still remains to be seen.
We can happily take some more questions. Thank you, Erica. I mean, this is a topic on internal investigations that we could spend a day's seminar on rather than just 45 minutes, as there's so many interesting themes to cover. But in the absence of other questions, may I just touch briefly with you, please, if I may, on one other hot area, which is issues you may face in your jurisdictions about legal privilege and waivers. And if I may, could I come to you first, Cami, for your thoughts on that?
Of course, with pleasure. This is a very interesting point and a major difference with some other countries. First of all, I draw your attention, you might have experienced that in the past, that there's no such thing as legal privilege for in-house lawyers in France. So everything can be seized. And this is really problematic in terms of dealing with discussions and sometimes discussions about a risk that we try to identify and assess. And our ability to write and to exchange within the company is very complicated. Of course, my exchange with my client are protected by professional secrecy, but even that is slowly diminishing in France as a decision rendered in 2016. That is isolated, but it's there, and it has not been changed or overturned whatsoever, says basically that professional secrecy, so even in your relationship as a client with me, is created, or comes to life, not only when you started discussing with me, but more when there is an actual coercive measure that is deployed by a regulator or by a prosecutor. So basically, if you're subject to a 6 months or 1 year shadow investigation by a regulator, you have not heard anything, you have not been subpoenaed, there has not been any request for sending of documentation, it being specified, of course, as I mentioned, sorry, I didn't mention that there's no such thing as a notification that you're subject to an investigation in France. You can be subject to an investigation by a prosecutor during years without being informed, unless, of course, you see the trace of an actual investigation, a raid, a request for documents. So you see, the moment when this professional secrecy is supposed to be created has been considerably postponed by the French Supreme Court. But that being put aside, a relationship with your client is protected, but the internal exchanges of the general counsel or legal advisor in the company with the rest of the company is not protected. So that creates a gigantic discrepancy. There are some things in France that cannot be used by a foreign regulator, but then can be used by ours. And the second thing that is absolutely critical is that there is no such thing as a waiver of privilege in France. You can have 100 documents that are covered by professional secrecy. If you decide to show your level of cooperation, to disclose or to provide 99 of these 100 to a prosecutor, the 100th remains protected by professional secrecy. Whereas in some other jurisdiction, you have waiver of privilege, either for one matter or for the whole procedure. And so I draw your attention to the fact that in international and cross-border investigation, even if you think that you're complying with your very own rules by providing to a French regulator a document that is covered by professional secrecy because you think it's interesting that this document is added to the file and you want to show your cooperation. This behavior could be regarded on the other side of the Atlantic, maybe, as a general waiver, especially if there is a joint investigation. So we can only draw your attention to these little differences that may be very critical in terms of consequences. And of course, as to give you a tip, generally when we provide an information that is requested by a judge or a prosecutor in France, and we do that willingly because we consider that although it's protected, we consider that this document should be provided to the judge to show the intention, the sincerity of the company, our willingness to cooperate, whatever the reason is. You have to explain that you do that to comply with the request, because otherwise you might be, of course, prosecuted in France if you don't cooperate. But it shouldn't be regarded as a completely volunteer disclosure of information, as it might trigger a waiver of privilege in other jurisdictions. So those are the discrepancy I was mentioning. And the last point, sorry, I was a little bit long, but this is a critical issue, We have faced recent decisions in France in which a document that was sent by a general counsel located in the USA, sent to France and protected in the USA by the legal privilege, was able to be handled even in the context of a private dispute when you raid a company to collect information in anticipation, not of an investigation led by a prosecutor, but a dispute, a commercial dispute. So the legal privilege was not recognized as enforceable in France in the context of a private dispute. So this is becoming highly complicated and sophisticated, and we draw your attention to this isolated yet existing jurisprudence in France.
Well, Camille, that's a really hot tip. Thank you very much. And Simone, your brief thoughts on this from the Swiss angle.
Yes, I try to be very short. I think the situation is very similar to what Camille relayed for France. Also in Switzerland, attorney-client privilege does not extend to communication or the work product of in-house counsel. And as in France, it is possible in Switzerland to waive privilege for instance, only for certain information, for certain documents, and not for the rest. And here, as Camille said, it's always good to consider what such sharing of information with authorities could have as consequences in other jurisdictions where it's not possible to have a partial waiver of privilege. And I think one interesting development in Switzerland, I mean, we have attorney-client privilege obviously applying to law firms, to lawyers who work in law firms. And but the rule is that legal privilege would apply to activities that are typical to a lawyer. So legal advice, representing in proceedings, etc. And there have been some controversial court decisions as of recently in relation to internal investigations where law firms have conducted investigations for companies. It was banks in particular. One case related to an investigation into certain accounts of a bank to assess whether the bank had been in compliance with its money laundering obligations. And the court came to the conclusion that this was actually a proper duty of the bank itself to investigate or to have a record on the duties of compliance with money laundering. And if a bank delegates such tasks to a law firm, this would not be considered a typical activity of a lawyer and would therefore not be privileged. And there have been similar cases going in the same direction. So as a lawyer, when you start conducting an investigation, always be careful in the way you structure it. Be sure that you do not only do a fact-finding exercise, but that you always link your activities to legal advice, to providing advice to the company in relation to its defense in a criminal or regulatory investigation. And, or for instance, another thing that you may wish to consider when you conduct interviews is whether you want to do proper minutes that reflect word by word of what has been said, in which case this could be considered a mere fact-finding exercise, or whether it would not be better to produce a memo with a summary of what was said and your assessment as a lawyer to have it as a product of legal advice. And these are all things to consider. I'm worried about this development because I think it's keys for companies to be able to rely on privilege also in relation to internal investigations. And obviously they can cooperate, they can waive, but I think it needs to be a choice and not an obligation. Thank you.
Thanks, Simona. And Erica, now wrapping it up with the final view from Stockholm on this topic.
Of course, be happy to do that. I think our situation is quite similar to the Swiss situation. We certainly, and the French, we certainly have a client attorney privilege, but it doesn't extend to in-house counsel. We do have a lot of discussion about how far does client attorney privilege extend in terms of, as Simona was referring to, is this merely fact-finding or is this proper legal advice? But for the time being, the case law is extremely limited. So we tend to think that it is a pretty far-reaching attorney-client privilege still that still remains. But we will see. I expect this to be challenged in court going forward.
Well, thank you all so much. I mean, as I say, this is a series of topics that we could spend a day or more on. We're really, really grateful to you for your thoughts and expertise, and particularly the tips you've given us about your jurisdictions. Fantastic. Thank you so much.